The principle that churches should not be able to wield governmental power is an important part of the whole idea of self-government. You don't want private institutions, especially but not only religions, to be able to control your life. And at a time when democracy is under such threat, no principle could be more basic than that. I was teaching a class in constitutional law at about the same time that I was writing the first edition of my treatise on the American Constitution. I kind of gave a hypothetical in class. I said, one thing that we know for sure, even though the Supreme Court has never really made any decisions about it, is that in our system of government, churches cannot wield power over your secular life. And one of my students raised his hand and he said, well, Professor Tribe, if that's true, why can't I get a beer with my lunch at Grendel's Den? And I said, Ira, I'm not sure what you mean. What's that got to do with the separation of church and state? He said, well, my Uncle Herbie fled from one of the countries behind the Iron Curtain because he didn't want to be governed by a tyrannical system. He wanted to be governed by people that he could vote for himself. And when he came here and tried to open up a business, he learned that the business couldn't serve liquor without a license, and the church next door said, you can't have a license. And I said, how can that be? I mean, why is it up to the church? Isn't it up to the Massachusetts Licensing Authority? And he says, yes, it was. It used to be a rule that any place within 500 feet of a church couldn't serve liquor. But that law had been changed, except the way the law was changed, instead of saying if you're within 500 feet of a church you can't serve liquor, it said whether you can serve liquor or not depends on whether the church decides to veto your application for a liquor license. As you can imagine, the church might have been more favorable to liquor licenses of people who were members of the church, especially if they were members in good standing, especially if they were members who, gave a little green stuff to the church every now and then. And I said, that's just outrageous. Why don't we bring a lawsuit? A civil rights suit against the Liquor Licensing Authority, saying that it was exercising power that had been delegated by this state law to churches, and that was unconstitutional. It was also anti-competitive, so I started working with my colleague at the time, Steve Breyer, hadn't yet become a Supreme Court justice, and he thought one of the things we should do was include an antitrust count in the complaint. The law was invalid because of the antitrust laws, the Sherman Antitrust Act. Steve and I and Ira, with the help of David Rosenberg, another colleague who had a lot of experience in civil litigation, worked up this complaint. We filed the complaint in federal court. Federal district judge, Judge Joseph Toro, a great judge, ruled for Grendel's Den. But then the state got that overturned by the First Circuit Court of Appeals. And then we got that overturned by the First Circuit en banc, that is the full First Circuit. And then the state of Massachusetts decided to take that case to the U.S. Supreme Court. And so what started out as a little question about whether one of my students could have a beer with his lunch ended up being a major case in the U.S. Supreme Court.
Mr. Tribe.
Mr. Chief Justice, may it please the Court. Let me begin by clarifying.
I've emphasized, because I know even in 1982, when the case was decided, the court was quite enamored of originalism, the original history. And I talked about how even in the American colonies, where there were established churches at the time of the founding of the Republic, those churches were not allowed to exercise government power. That was an important distinction. As a matter of fact, the history of England, where there was an established Church of England, took great care not to give churches the power to veto liquor licenses held by pubs nearby. There was a statute in England that specifically prohibited churches from deciding which pubs could serve beer. So part of the oral argument was interesting because of something I had totally not anticipated. Because we won the case on the First Amendment ground, the state challenged that in the Supreme Court, but didn't discuss the antitrust ground, and suddenly Justice Stevens leans over and says,
well, but if the Sherman Act applies, there isn't any constitutional issue remaining. It's perfectly clear that if there's a violation of the Sherman Act, then the Supremacy Clause requires that it be enforced.
Yes, but
Justice Stevens decided to go back to part of the case that had really disappeared after the very beginning.
The doctrine of avoiding constitutional issues would be served by addressing the Sherman Act claim first.
My jaw, I thought, visibly dropped. But I had to come up with a reason. I mean, it's always nice to win a case on a different ground, but on that ground, if we won, it would have been a long trial. We would have had to then prove on remand in the district court in Massachusetts that this anti-competitive practice really occurred. We'd have to put the priest on the stand. It would have been a nightmare. So he said, we do have a principle in this court that if we can decide a case on a non-constitutional ground, we ought to do that. Wouldn't that be a less dramatic holding? And I thought quickly and said it would actually be a more complicated holding, Your Honor. It would actually create an entanglement between church and state. You would actually have to probe the motives of the clergy. And for the government to probe the motives of a religious institution violates a whole line of this court's cases, saying that government has no business intruding into the theocratic affairs of religious institutions. And that satisfied him, and the antitrust issue was never heard from again. And that was probably the most exciting part of the argument, because I felt pretty damn good that I had come up with an answer to a question that I hadn't prepared for. After the court ruled that it was unconstitutional, we had to actually apply for the license, and that was kind of a grubby process. They wanted to know, well, aren't there enough liquor licenses in Harvard Square? Why should we grant a license to Grendel's Den? Well, I couldn't come up with a very good reason other than one. I said, well, if you don't, generations of law students will really think that the law sucks. It's not going to be worth very much if you win a big case in the Supreme Court, and then the reason you litigated it in the first place turns out not to have justified all the time and effort that you put into it. And they said, so we're going to go down in history as bad guys if we deny the license? I said, not only as bad guys, you'll be the villains in the great story about whether the separation of church and state really means anything in this country. Don't you want to be the heroes? Appealing to their egos worked. They granted the license, and the rest is history. It's a reminder that public officials can sometimes actually care more about doing the right thing, and that's a source of hope, which could hardly be more important in a time when hope is hard to come by.